Good evening, Mr. Chairman and board members. My name is Jeff Bragman, and I represent neighbors in opposition to this application. And tonight we're also joined, as we have been in the past, by some concerned residents. And you may be aware to some extent that there is public opposition that is considerable to this application. The Southampton Association has circulated a petition to this newer version, and we are going to be presenting that to you tonight with 260 signatures on it. The application remains incomplete in some essential requirements. The plans that we got had no dimensions on them. We complained to the board office, and apparently, once again, on the Friday before the hearing, new plans were submitted. So we have not had an opportunity to look at dimensioned plans. The last plans were not dimensioned, and therefore we were unable to confirm the representations about some of these changes. And I noticed, I think I heard some slight changes in the numbers tonight. So we'll have to get back to you once we have those plans. There are things that are missing that the applicant has just not brought into you. The board has asked for a scaled streetscape. We have yet to see that. The board also asked for a burlap test, which would, I think, disclose some of the massing of this building. We haven't heard about that. The board asked for an east to west view in scale so that they could tell the impact on the eastern property. We haven't gotten that. We still haven't gotten a written confirmation on a pretty basic point in this application that it's within the historic district. In fact, the applicant has consistently also said it's not visible from a public street. We haven't gotten a statement from him saying that it is. And ultimately, the board does have the authority to determine that, but your own attorney said the application was incomplete because of those omissions that I just mentioned.
Hey, Jeff, excuse me, I don't think I've made any comment on this application.
I heard it in a public hearing when I was present. You said the application was incomplete because it didn't answer whether it was in the historic district or visible from a street.
Well, I wasn't here at the last meeting.
I know you weren't. It wasn't at the last meeting. It was at a prior meeting. Chapter 65 gives you some guidelines here, and I want to go through them.
Just for the record, I don't recall that, and I wasn't here that meeting. Yeah.
But
the last meeting. It was a couple of meetings ago.
The application in the file is in error on those two accounts, so he is correct on that. And we did bring it up. The application on the 5 points says that it's not in the historic district. I think that was, to your credit, I think it was crossed out, and that it wasn't visible from the street. So I think it's a technical point that the application has to be corrected.
It was corrected, if I may.
Okay, if it was, I didn't see it, John.
Historic district, and it's in the historic district, and the thing about it not being visible from the street was based upon not my office, but I'll take responsibility for it. One of the other entities involved, they copied it from the application for the demolition of the two structures that are on the property now, which were not visible from the street. And indeed, that was one of the findings in the demolition. So it's in the historic district. There's no escaping that. And both of those issues were corrected by me. So I don't know why that.
And what about? I was in the building department today, and I was told there were no new plans.
Mr. Bragman had the new plans over 2 weeks ago, as per your direction, and they were also submitted to. Of course, they were. He had them the day after we submitted them, the revised plans. I have.
And those are the ones that are in the file. That's what I'm asking you.
Just so that I know dates, is that the set of plans that were dated the 21st of April? Okay, so April 21st was the date that they were received.
Well, first of all, there's no requirement that they be dimensioned, and then because we respect Mr. Stott as a local architect, there's no requirement, but we dimensioned them. That doesn't mean it's incomplete. And talk about no good deed going unpunished. When he asked us to dimension them, we quickly did.
I think the issue is time to consider, and I know you want them to consider it.
I'm glad to hear he's admitting it's in the historic district and that it's visible from streets. I want to talk about...
We're looking at the application as if it were in the historic district. It is on the agenda within the historic district, and therefore it will be identified and reviewed as it is in the historic district. So there's no question.
If I can move on, I want to address the guidelines. Chapter 65(5)(b)(3) says new construction has to be compatible with the character of nearby properties in the historic district, and that in applying the principle of compatibility, the board is required to consider the following factors: the general design, character, and appropriateness of the property appropriateness to the property of the new construction. It also requires you to look at the scale of the proposed new construction in relation to three things: the property itself, the surrounding properties, and the neighborhood. And I hope that you all have this booklet, the design guidelines, which defines scale, and it means size. And in addition, they provide some other principles for design, of historic design, and definitions to guide the board. And I want to start with one of them because it's very significant in this case, and that is massing. And what the design guidelines say is that massing defines the shape of the structure, which in turn suggests the volume. And it also distinguishes historic construction by saying that historic houses typically follow the principle of additive massing, which is the placement of additions of different sizes and volumes so that they can be distinguished from the main building. When you see these historic buildings that have been added onto, you see that you can see where they've been added onto it, and it makes it sort of lively, and it does not present, as modern buildings can do, one big block of a building. And that is a major problem in this case, because the massing of this building is largely driven by the desire to put all the living space on the second floor. Apparently the owners want the kids and the parents to be on the same floor, an arrangement which I wish them luck with as the kids get a little older. They might not like that so much. But it's still, even with this new design, which we scaled out at 185 feet, the length of the north-south walls. It has very long walls, and that's without including the stairway and the deck that add to that length. And the problem with the design of the building at its heart is that it's got a uniform height along that 185-foot run. And it's a very blocky design because the height is uniform. And that is something quite different than you see in typical historic architecture, particularly in this neighborhood, which is the oldest part of the Summer colony and has some of the finest examples of old-style shingle architecture, two of them owned by my two clients. And to our eye, the building still looks commercial. In fact, at the last meeting, you may remember the architect himself said that he efforted to make it look less hotel-like. And we can't see, frankly, having attended a Vince Scully lecture back in the day, I like the pictures that the expert showed, but I can't see anything about those pictures that looks like this building that they're proposing to put up. It does not, to our eyes, seem like a blocky, massive, uniformed height building has anything to do with sort of the liveliness of the shingle-style architecture, the varied volumes of the shingle-style architecture, and frankly, the verticality of the shingle-style architecture, and the variety between the verticality, like the tower in the beautiful house that's owned by the Mangers as compared to the rest of the house that sort of dances around it. The guidelines say that new construction should follow the general massing of the surrounding buildings, and that if the massing varies, it should not introduce a new variant. This is a new variant. This doesn't look anything like the Manger house, nor does it look anything like the Michaelchek house. And the attorney for the applicant continues to give you a false choice here, because he says in a very dignified voice, well, no one wants us to do replicas, and the replicas from the 90s look so bad and identifiable. That's not the choice that we're given here. It's not either you do a replica and turn this area into Disneyland, or you do it my way. The answer is that the massing is supposed to reflect the massing of the buildings around it. And, you know, if you just walk the neighborhood as I have, there's no question that there is that this mass, this two-story uniform mass across 185 feet, looming over the neighbor, looming over the Mangers most closely, looming over their small guest house, which is about half the size that they were permitted to build, is a new variant, and it doesn't reflect its neighbors in any way, shape, or form. Now, the massing is also related to the siting of the house close to the Manger and Michael Check properties. And I know we've gone around on this, and we've heard comments that, oh, we don't have site plan powers. We don't have site plan powers. Just because the word is the same, site plan, and we're talking about where this house is located on the site, does not mean they mean the same thing. No, you don't have site plan review powers. Those are in Chapter 11638, and it's an application for any use, building, or structure except a single-family dwelling. We're not talking about site plan review. We are talking about the siting of the house. And the siting of the house is a factor that is mentioned in your architectural design guidelines, which are binding on you. And those guidelines say that historic architecture respects the relationship of buildings to one another. They don't angle for a better view. Southampton historic neighborhoods have regular spacings, which preserves visual unity. And it says in the guidelines, the characteristic elements of the immediate environment and neighborhood include setbacks and spacing. So it's not site plan review we're talking about. We're talking about honoring the guidelines which tell you that in a historic neighborhood, characteristic elements are reasonable, predictable, and I would say neighborly spacing of the buildings. That was how people built buildings when they weren't building big, look-at-me, high-tech new buildings. And this part of the historic district is the oldest part of the historic district. It is the first place where a successful New Yorker came and had the vision of creating a summer colony right here. It's the oldest part. And that is reason for you to pay a special attention to this. And, I heard a lot of words here, about the building's humbling presence and its cottage-like feeling. And, the overhang looks like a cottage. Well, a cottage doesn't have a 185-foot long run at 2 stories. There's nothing humble or cottage-like about this building. It looks like an administration building in a university setting. What your guidelines say also about towering over is that new construction should never tower over its neighbors. That's precisely what it does. And it's precisely why the Manger family is in such anguish over this. Anguish. And, it's worth paying attention to the Manger family. I've been reading a little bit about them. They've been wonderful stewards of the land and that property. And that is a spectacular property that is a keynote. It's a jewel in the crown of the village of Southampton. It's one of the most important buildings you have, as is the Michael Check property. And I loved it because I didn't know which building was which building when I first went to the neighborhood, but I had read a description of the Michael Check property. That was the old fleur-de-lis building, now called Windchaser, I think. And it said, it twists, it dances, it's light on its feet. It exerts every effort to catch every view from every angle. And you know what? As soon as I saw it, I went, that's got to be the house. Because you can see it. It's dancing, it's light on its feet, it's connected to the ground. This is a brick. This is not a dancing house. And there's been no mention in this whole discussion about the Mangers' guest house, which they kept at deliberately small scale, half the size they could have built, 32 feet tall, from natural grade, not from finished grade. The roofs may be slightly lowered, the shape might be slightly changed, but from what we can tell, and we can let the architects debate this, the height remains 40 feet from natural grade. The reason that it comes down is not because the building is lowered, it's because they're raising the grade by 3 feet. The wall height, actually, to the soffit the under part of the roof, by our measurement, is slightly higher than it was. And this is what people on the ground see. You may see the roof height that was lowered if you're 1,000 feet away or 1,500 feet away, but when you're near the building on the ground, you have to understand the human scale of looking at that building. What you're going to see is a 24-foot high wall. You're not even going to be able to see the roof height. And, you know, I have to say, I think it's a little disingenuous when I hear, you know, the consultants say, this is all about volume. It's all about volume, and we've reduced the volume 12%. Yeah, they've reduced the volume 12%. It's all in the roof. That's where they've reduced the volume. They've reduced the square footage, a munificent 1,100 square feet. That's what they cut this building back, 1,100 square feet. That's probably a closet.
I would love to have an 1,100 square foot closet.
No, that's my house.
That's my dream.
Looking at the Commuto house, and you know, and they talk about the height of the Manger house. What's the name of it? It's not coming to my mind. What's the Tapadoon? And you know, they go, oh, it's so tall. It's, you know, it's so tall, and we're not nearly as tall. Yeah, you're not nearly as tall, but you're 180 feet, 5 feet wide. It's enormous. And you know, in reading about the shingle-style architecture, what the commentary is yes, they have some verticality that may pierce the general height rules, but it's the exception, not the rule. And you shouldn't introduce, again, a new standard here, which this building does. So, and you know, you can tell, I didn't recognize the Commuto house, Wilden Manor, the guest house, from the photographs I saw from the landscape architect. You know why? Because when I went there recently, and you know, things are pretty much in bloom, you really can barely see that house. And it's a big house. It's like a 10,000 square foot house. Why is it that you can't really see it? Because the architecture does what it's supposed to do. There's additive massing, there's variety, the roof lines come down to the first floor, it's not all at one height. And the result is you have a pretty large house, which I'll get to, but
we're giving a lot of latitude because you are representing a number of neighbors and interested parties, so we've been giving a lot of latitude. You do recognize that at times we've given a time contingency, but we're going to ask that you...
I would appreciate it if you would let me continue and make a full presentation tonight. There's nothing worse than trying to rush through what I have. I've sat through probably 4 hours of the applicant's attorney giving his testimony, standing up with his witnesses, they talk together. There's been probably about 4 hours worth of their talk. My client's investment in their properties is every bit as significant as the applicant's
Which is the reason why we've given the amount of latitude that we have thus far.
Please let me continue so I don't have to rush.
Ask me time sensitive, please.
All right. And I think you can see it, you know, when you look at the Commuto house, that there's something different. It doesn't loom over its neighbors. It doesn't tower. It does what it's supposed to do. The overall height is related, in this case, we think, to the impact of the plan that they have for fill. We would like to see a real plan. Like, where are they going to put fill? How much is it? It looks to us like they're going to put 3 feet of fill across the entire property. They built an enormous retaining wall. I don't know how they got that without architectural review. I don't know, but it's there. And what I wanted to say to you is that in applying the standard of compatibility of the project to the site, the board, again, under the architectural design guidelines, is required to consider the importance of features or property to be changed, and it includes the moving of any land, trees, plantings on a property within a historic district. Are there any other properties where you've granted a certificate of appropriateness where you've let them fill the entire property 3 feet to raise the level? I don't think so. We're not aware of any. And we think that is something that, A, they should describe, you know, in detail so we know really how many cubic yards they're talking about and what it's really going to do to the property. I think we should know before we go. And as I said, we think it affects the height measurements that they're doing. This is a massive amount of fill. Also, I want to talk to you about comparative scale. We don't have to guess what the word scale means. It's defined in the architectural guidelines. It means the measure of the relative or apparent size of the building. And it's the overall dimensions of the building that define the scale. And it goes on and it says that scale, the relative scale, is one of the most important features in determining what's compatible with its setting. And a stark contrast in scale between adjacent buildings is visually disruptive. We think there's a stark contrast in scale, which I will get to. It also says that new construction has to be compatible with nearby properties in the district. Now, when council gave you a list of, he's the one that it seems to me expanded this discussion to, is this the biggest house in the village? The real question in front of this board is it compatible with nearby properties in the historic district and with nearby historic properties, not the entire village? And if you look at his chart of, I think it's 12 properties, a third of them aren't even in the historic district. So why is that relevant? It isn't relevant under the standards. The board is supposed to consider the scale of the proposed new construction in relation to the properties, surrounding properties, and the neighborhood, and then it is supposed to make a determination of visual compatibility with the surrounding properties. Another thing missing from the record is comparative elevation drawings that show the surrounding properties and comparative perspective drawings that show the surrounding properties. These are required in the admission, in the application.
So that's what was presented, and I understand you have not seen this evening. It was presented to us this evening. They gave a comparative review, elevations, as well as looks like a photo from Google Maps showing demonstrated what the structure would be imposed.
Okay, we'll have to look at those. We haven't had a chance to see
expressing that they're a part of the file.
Now,
But one from looking east to west has been excluded.
Looking from east to west.
that was something that was particularly asked in a couple of meetings, including the last meeting.
That was asked by me because I can't.
I also want to state for the record
A lot of chatting.
Okay, well, I'm asking.
Please.
that the design review standards also explicitly involve the visual compatibility with surrounding properties of the front facade proportions, which is our complaint here today, the spacing of the properties, which you are empowered to look at and evaluate, and the setbacks. Now, I've heard council give 2 law lectures on why you can't look at the size of the building, although your standard absolutely requires you to look at the scale of proposed new construction in relation to the property itself, surrounding properties and neighborhoods. 65-5C. He wants to put a big black magic marker through that section and say you can't do it. He also wants to put blinders on you because he doesn't want you looking at comparative scale. The discussion that I've heard from council about the legal precedents, I think, requires some answer. The Ferrara case did not involve a house in the historic district. It was a decision made under Chapter 116 of your code. It doesn't take a law student or a lawyer to know that a decision made under Chapter 116 of your code is not binding on you in this application because we're deciding it under an entirely different section of the law. You're within Chapter 65, which applies to the historic district. So Ferrara, despite the puffery about how important this case is and how it binds you and you can't even look at it, it's so important, says the attorney on the other side, that he hopes he doesn't hear any discussion about this whatsoever. Well, I want to give him a little discussion about it. Ferrara has nothing to do with this case. We're dealing with Chapter 65. It's not Chapter 116. It's a simple arrangement. The town has a maximum gross floor area maximum that it establishes based on a formula. It has nothing to do with opening your eyes and looking. It's just a calculation on paper. It's what lawyers call a ministerial act. The building inspector can go, okay, you got this much square footage, this is your calculation, this is how much you can build. He doesn't mention that it has a stop sign in it, which I think is important. it won't go above 18,000 square feet because the village board was worried about the steady escalation of large houses on larger lots. So it wanted to put a stop sign there. And I think that's something we should consider in this case. So Ferrara has nothing to do with this case. Now, I litigated the Pine case, and I was looking over the papers today, to make sure I could say this as clearly as possible. The Pine case, which involved Farrell Builders, was in the historic district. And we sued and made the same argument that I'm going to make tonight, that a ground floor area maximum doesn't mean anything in terms of your ability to review under Chapter 65. Now, the other side made a motion to dismiss the case on grounds that had nothing to do with the statute, nothing to do with the question of how they work together, does one override the other. They just said two things. They said Mrs. Pine didn't suffer the kind of harm that would enable her to be a plaintiff in a case, petitioner in this case. That's called standing. And they also said, our building is up, and therefore there's nothing left to decide. So they made a motion to that effect. Now, as your attorney here tonight knows, we were going to brief the substantive issues, the merits of the case on how the GFA interacted with the architectural board requirements. We had been on stipulations that allowed us more time to put the briefs in. It was actually the village that needed more time, not us. They needed more time. And he made a mistake at the end of our discussions and failed to file a stipulation with the court. So what happened is, it was never, I hope I'm making this clear. I know it's more law than I like to talk about, but I want you to understand this. So at the end, briefs were never filed. We never discussed the substantive issue of whether the GFA overrules the ARB or whether they can work together. We never briefed that issue to the court. It was near Christmas, and the judge decided the case. But what did he decide it on? He did not decide the substantive issue. He never even addressed it. He just said, I'm granting the motion to dismiss, period. Now, the only grounds that he could have dismissed on were injury to her, that she didn't have the right to sue, and that it was moot because the building was built within, believe it or not, like 3 months. That building was up. Now, he also got a building permit before you even issued a written decision. Don't know how that happened.
That's just not true, Jeff.
It is true.
And you heard that in the appellate division.
It is totally true.
It is not true, Jeff.
That is incorrect.
It is not true.
We'll just have to disagree on that.
Bring in the documents.
We'll just have to disagree.
No, we won't. You're not going to get away with making a false statement to this board.
It's not a false statement. No, I'm sorry. But I'll disagree with you.
False statements. I'm not going to sit down.
At any rate.
Lying.
At any rate, I want to talk to you about the appellate division. It's really unimportant. The house got built within 3 months. When we went to the appellate division, and we had an extensive argument on the merits of the case and talked about the fact that the building had already been built. What happened in the appellate division? They didn't decide the issue. They decided that the case wasn't susceptible to a legal remedy because the house was up. Lawyers call that mootness. They dismissed the case on grounds of mootness. So all this talk that you're hearing from counsel, that, this was in the argument, and that was in the argument, and so now I've got 2 cases supporting me. He doesn't have anything. He's got Ferrara. That's the only case he's got. It's not in the historic district. Now, what I've said to you before is that it's a simple way the law works. Generally, you have a maximum gross floor area, but when you're in the historic district, you have to subject your plans to a visual comparative judgment by this board. And that's a discretionary judgment. And you should understand that every case that comes in front of you, I think you understand that, I think you probably know this, has to comply with zoning. That means you're never going to see a house that doesn't comply with the GFA. They're all going to have to comply. The fact of the matter is that in the historic district, there's an extra level of review, and it's not formulaic. It's not just an equation on paper. Why? Because that doesn't tell you anything about the way things look. You're required to open your eyes, and you're not required to put blinders on. It reminds me of Chico Marx in one of his movies where he said, who are you going to believe, me or your own eyes?
We're going to have to ask you to wrap up.
Okay, I want to talk to you about the size of houses.
We're going to have to really, I mean, with all due respect, I mean, literally, we've been in discussion with your review for some time now. Again, typically would ask between 3 to 5 minutes, and it's been greater than probably more like 15.
I appreciate it. I've never heard the chairman or any board member ever, in all of the meetings I've sat through, say to the counsel for the applicant, we've heard your argument. He filibustered tonight. He didn't say one word tonight that he hadn't said in the last hearing. I think I'm entitled to make a full presentation.
Whether the applicants are within this particular board or any other board, the applicant has an opportunity and the option to present his application. In any other municipal board, they also say anyone would come to either refute or to discuss whether support or objection. There's usually a time limit. We haven't invoked that this evening. I'm just being really nice, and we've been very, very...
I appreciate it. I want you to work with me because I have facts I want to give you. I also want to tell you that before the last meeting, they adjourned the case 2 months. So it's not like there's any urgency. I mean, you know, heaven forbid, if I take up too much time and a couple people can't speak tonight, you can adjourn this case. And I would ask you to give me the same, you can adjourn it and continue the hearing. In other words, I think you have an obligation to hear the opposition in full with the same kind of ground rules you've given to the applicant. He has no different standing in this case than I do. We own valuable properties. I just want to be able to present you some facts. I'm not talking nonsense here. I'm talking about your code.
No one's measuring the merit of the information you're providing.
Well,
no one has said that.
Let me continue.
What we're saying is that...
I'll try to wrap up as quickly as I can.
Thank you.
If you want to look at a comparison of size, and you are required to look at the comparative scale under your standards, we did it very simply. We did 36 properties nearby. We got the village's list of how much square footage in each of the houses, and we took the average of those 36 properties that are relatively nearby where we are. And I have a list here. I'll give it to you. There are a couple extra. And it shows that the average size property, when you divide it up, is 5,611 square feet. That's the average size. You can see the addresses where they are. Okay? Now, the applicant has done something slightly different tonight, and I think it's worth looking at. He's constructed a formula of his own. He's taken the house size and he's divided it by the lot size. And the reason he's done that is to convince you, he wants to show you some numbers, that when you do that, when you create that fraction, he comes in at like 10%, and there are many others that come in at 15%, 27%, all higher percentages. So he wants to show you, like, I'm low down in that category. But there's a problem with that. First of all, this is not a formula from zoning. This is just a formula he came up with. And if you think about it logically, and I'm no math expert, but I've spent some time looking at this, if you do a fraction and you have a big lot that is the denominator, the lower number in the fraction, it's going to make the overall percentage lower. So this formula by itself favors large lots. It's going to tend to produce a lower number for large lots. And if you go through the lots that he looked at, and you see the lots that have a higher percentage, something unusual pops out at you. Like in 2 Fairley, he cites that they've got 16% comparison between living area and lot area. And he's only down at 10% or whatever it is. The problem is 2 Fairley is a tiny lot. It's got 27,000 square feet, and it's got a small house, a 4,400 square foot house. So what I'm saying to you is the percentage that his formula produces doesn't tell you anything about the way the house looks, because he doesn't want you to focus on the way the house looks. Same thing on 6 Fairley, 13% higher than what his percentage is. But it's a tiny lot, 3,700 square feet with a 5,000 square foot house. Same thing for 8 Fairley. It is a percentage of 19%. That lot is just under an acre, and it's got an 8,000 square foot house, half the size of his house. So what I'm saying to you is...
explain all this to us.
We
get
saw
that.
it.
Okay. I don't want to belabor it, but, you know, this is why I think it is so important for the board to do what the law requires it to do and do a real visual comparison, And I think the burlap test, in this case, where they string a line of burlap, would be very helpful because we are talking about a massing that's very unusual in the neighborhood. We also applied the GFA. We looked at GFA figures for the house, and again, they don't always tell you how big the house is. What they do tell you is how much of the available building area you've used, and it looks to us that they've used, I think it was, I don't want to misquote it, so I'll have to find it, but I think it was about 89% of their ability to build they've used. Size escalation is an important issue for you to think about. There's going to be one coming in on the other end of Lake Agawam that's going to raise the same issues. This is a critical part of the summer colony. It's where it started, and we think it's exceedingly important that you not put blinders on, not just look at lines on paper. This is not about lines on paper. It's about the way the house looks. I'd like to say a word about the petition that is going to come into you tonight. There is a lot of community concern about this. I've been with this attorney before when petitions have come in, and he always raises a claim that, well, they don't have standing, so it doesn't really mean anything. And I want to say this to you again. Standing is a rule when you want to sue somebody. We're running a public hearing here. Anybody can speak. You don't have to be a resident of the village of Southampton. You can be a concerned citizen of the town or anywhere. That's what a public is. The petition itself, and I've heard counsel denigrate these petitions and say, oh, that's just a form letter and everybody signs a form letter. So I want to say, without belaboring it, that the petition is the oldest and classic mechanism in the United States government for addressing your government. It is the first and most essential right of American democracy. It is what triggered the Declaration of Independence. They didn't say, you didn't let me talk. They said to the king, you wouldn't listen to our petitions. And when the founders of this country established a constitution and they wanted a First Amendment, the very first right they protected was not free speech, it was the right to petition the government. That's what these people are doing. Do not throw this petition in the garbage can. It shows there is significant opposition. It is not irrational. It is not emotionally driven. It's driven out of a sincere concern for protecting a vanishing resource that could easily be lost. And I ask you to keep that in mind. And as to the new matters, I may ask you for more time on another date to answer some of this new material that has come in.
Thank you.
Thank you. I appreciate it. I do understand I took a long time.